Welcome in, true crime lovers. Okay, so Sarah Boone, the state has filed some motions in regards to the latest and greatest that I uploaded earlier today. So Sam's here with me, PI, Florida private investigator Sam.
Hi.
Thank you for joining me again today. I appreciate you.
Thank you for asking me. Happy to be here.
Oh, so nice of you.
Hmm.
Okay, all that to the side. Let's get down to this docket. I'm going to pull up what I have here.
They've been busy.
Yeah, I see all that. Okay. Notice for additional discovery. So this is the state's response right here. Uploaded 9/8. There's no way it just hit the docket.
I know, and there's stuff there from today too.
I'm just like floored because I'm checking the dockets like regularly, and this stuff isn't coming up. So it's kind of frustrating. Okay, here's the first one. We've got a state's response to defendant's motion for statement of particulars. Did you already look through this?
I did.
Do you want to explain it?
I can try. Um, so what Sarah's lawyer was asking for was more details in the charging document, um, because it's not very specific. So they asked for a statement of particulars, and this is the state saying, we don't have to do that. Because there's no exceptional circumstances in this case that would require it. And then they're citing two different cases. This one, Miller v. State, statement of particulars is not necessary in this case for the following reasons. There's no variance in the information and the discovery as to date, time, and place of the offenses. So basically, we know where it happened, we know who it happened with, and
We
we
have a
know when.
recording.
Yeah, exactly. Um, Wait, you went too fast.
Oh, I'm so sorry. Okay, go ahead.
So there is no variance in the information and discovery as to the name of the victim, and the information filed tracks the statutory language, putting the defendant on notice as to the law she has alleged to have violated. So I think I told you this the other day, but I went back and looked at the charging document, and it doesn't have a lot of details. Like, in my area, I typically see something called a CRA, which kind of lays it all out in detail. And if I'm remembering correctly, I did not see that for this case. So the state is just pushing back, saying, we don't have to do that. Sorry, no.
Oh, okay, I gotcha.
That was because if you'll remember, so this was one of the first defense filings, was a motion for statement of particulars. They're trying to get beyond somebody is dead.
Right. Okay, so let's move on to the next one because that's kind of okay. State's response. The next document is this one, and it says state's response to defendant's demand for supplemental discovery. So they're
Right.
actually they're actually responding to his or her, because I read that one where she uploaded.
Yeah, no, so that one won't be counted, like, at all.
I didn't think so. Okay.
That will be stricken. The defense filed two motions the other day. One was for additional discovery, I think, and then the other one was for supplemental discovery. And I've never seen this happen before. Not to say it doesn't happen commonly. I haven't seen it before. The state's like, no, we don't have to do that either.
You know what? You know what I think, Sam? And somebody made a comment in the below one of my videos that said, "You know what? I feel like this guy's just throwing everything at the wall to see what's going to stick."
Oh, 100%. Yeah, that's totally correct. So a couple of days ago, he asked for the Orange County Sheriff's Office standard operating procedures for interrogations, I think. It was a filing from a few days ago. So that was one, and then he came back again asking for the Miranda card and something else. So this one is either going to be okay, so what they're saying here is that they don't have to give them the information, because if she just went to the sheriff's department, she could get what she wanted. Like, she
If
doesn't
the
have to.
defendant if the defendant were to exercise due diligence, she could easily obtain
Yeah,
the information from the Orange County Sheriff's Office.
exactly.
Uh,
Exactly. So basically what they're asking for is, like I said, the standard operating procedures for when a defendant is being interrogated. Because remember, on the first news conference, we learned that James Owens had a problem with the interrogation, if you'll recall. I think that was his language.
Yeah.
Okay, so that was the first thing he was asking for. He wanted to see if they had violated any policies while
And then he
questioning
asked
her.
for, and then
And
yesterday or
then,
this morning, I noted that he asked for the specific cards that they read
yes, that's right.
when doing Miranda. Did you made a comment? You thought they had updated those?
Updated what?
The Miranda rights? I thought somebody said something about that. Maybe I read it in the comments. I'm confusing. Y'all, I've had like 2 hours worth of sleep in 2 days. Sorry.
So I went back. I was talking about Miranda with some of the people in the comments the other day. And what I did was I went back to Sarah's interviews, and they did read her Miranda for her interview in the car, as well as when she was in the room. So
Yeah, did you watch my video yet that I did this morning?
yes, of course.
Oh, okay. Because I wanted to go ahead and just show that on that video, because I'm like, okay, if you're going to ask us about the Miranda rights, we're going to see exactly what you're talking about. So I put that on that video too. But my
Right.
only
And
my
I'm so
concern
sorry.
is when they no, oh, it's okay. My only concern is when they walked up and started asking her questions. They introduced themselves and they started asking questions. That was the only part that I was like, oh, I don't know. I don't think
Oh,
so.
right. Yeah, I did watch that this morning. Yes. And I don't think there's an issue there, because at that time they didn't know what had happened. However, she does run her mouth a lot, but they don't have to read her rights in that situation. When she gets in the car to be recorded that same day, and that's why they do it. That's why they get in the car, is because their body cams will activate inside the car and produce a good audio recording.
And then they can do the Miranda.
They did, and they did.
Yeah. Okay.
So I might have stirred that up by everybody was speculating on what they thought the attorney might like to keep out, or what he was trying to get at, right? When he said that he had a problem with the interrogation. And I said, well, were her Miranda rights read? And chat said yes. And I just needed to go back and look for myself. And then I saw your video this morning. I think she didn't need it at the time, that they were just asking her what happened.
It says if the defendant has attempted to obtain those records through the means available to her and failed, she has failed to state this in her motion. Therefore, the defendant's demand for supplementary discovery should be denied.
Yeah, they're not interested in giving Sarah anything else. So
I
basically,
love
they're
this.
saying, go on over to the Orange County Sheriff's Office and ask them for their standard operating procedures. I tried to find it for interrogations. I found everything but that.
Okay, so here's the third document that the state uploaded today. State's response to defendant's second motion for additional discovery comes now the state of Florida by and through this undersigned assistant state attorney, and stats as follows. The state filed its response to notice of discovery on March the 20th of 2020. You got 4 years ago. Paragraph 5 of that pleading outlines the controlling law on this issue. State versus Wright holds that the court must first inquire whether the information the defendant seeks is available if she would exercise due diligence. I like that. If the defendant were to exercise due diligence, she could easily obtain the information from the Orange County Sheriff's Office.
So they're just saying, we've given you everything we're going to give you. If you want something, go get it yourself.
Okay, then comes the next thing on the docket, which is the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome. She said, what? Okay, guys, I have to tell y'all the background of us starting this recording. I was at the hospital with my uncle, and so I took a nap. And then when I got up, I was kind of playing around on my computer, and Sam texted me and said, oh my gosh, the state just uploaded a bunch of stuff. And I've been looking through it, and I'm like, oh my God, let's go live. So that's where we are. I have not looked at this yet.
State's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome, and state's motion in limine and state's motion for examination by state expert.
On
Okay.
September the 6th of 2024, the defendant filed a notice of intent to rely on the defense of battered spouse syndrome. Florida Rule of Criminal Procedure 3.201 requires the defendant to include a statement of particulars showing the nature of the offense the defendant expects to prove. The defendant's notice does not include any particular facts which, if produced at trial, would allow for Dr. Julie Harper to opine that the defendant suffered from battered spouse syndrome. Therefore, the defendant's notice is legally insufficient and the court should strike the notice. Furthermore, the defendant only lists Dr. Julie Harper as a witness to show the defendant suffered from battered spouse syndrome. An expert witness cannot be used as a conduit to introduce inadmissible hearsay evidence, such as the defendant offering the defendant's hearsay statements. I'm not going to read the statutes. We'll get into that later. Therefore, the defendant should be precluded from mentioning battered spouse syndrome in her opening statement. And Dr. Julie Harper should be precluded from testifying until the defendant testifies to underlying facts that would allow for the expert's testimony. I kind of get this. Okay, I don't have a law degree, but I kind of get what they're saying here. The defendant has previously provided statements to law enforcement. Therein, she claims she accidentally left the victim in the suitcase overnight. Battered spouse syndrome testimony is not admissible if her defense is that killing the victim was an accident. You can't have it your way, Sarah. The defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant has presented evidence of justifiable use of deadly force. Finally, the state's requests the defendant be ordered to submit to an examination by an expert of the state's choosing. They haven't already done that?
No.
When do you think they would have?
No, because she hadn't put this notice in. I think that maybe it might have gone in the notice of intent to rely on battered spouse syndrome. I think may have been brought up once before, maybe when Mauricio Padilla had the case.
Oh,
But
yeah.
since and I'd have to go back in the docket and look, but now we're on new lawyers, and
It was Padilla. It was Padilla because I was just looking at the outline the other day.
so
He's the first one that brought in Harper, Dr.
right,
Harper.
and so that's why the defense now wants to use Dr. Harper, because they can build on the times that they already met. But the new defense had to file a new notice of intent, and James Owens was talking about this in court that day that he first appeared, that we saw that, he wasn't going to have enough time because it's a 30-day notice. So no, the answer is no. They don't. The state, I'm assuming, unless it got done under Padilla, the state did not have a chance to subject Sarah to their expert.
Okay, so that makes sense because I feel like in reading this in layman's terms, I feel like they're saying, look, you can't use this. I didn't realize that the state could say you can't use that defense. I thought that, hey,
Yep.
I can use any defense I want to use.
No, that's what I texted you. It's like, oh my God, I think that they have a good shot of saying she can't use this defense. So on September 6, 2024, defendant filed a notice of intent to rely on the defense of battered spouse syndrome. So you covered that, I think. And we saw James Owens talk about it in court. And this is why Julie Harper has been brought back into the conversation. So under the Florida Rule of Criminal Procedure 3.201B requires the defendant to include a statement of particulars showing the nature of the defense the defendant expects to prove. Now, I was reading about this for the video that we are working on, and I will be able to provide a better, more detailed explanation of this. But basically, there are three versions, and like I said, I'm not finished researching, but as I understand it, there may be three possibilities for the battered spouse syndrome. One would be self-defense, right? So what they're saying here is if you're going to rely on it, you have to say under which of these three you're going to use. And I think one is self-defense. One might be justifiable homicide. I've read a bunch of the cases. I will have it all laid out later. What they say here, though, is that the defendant's notice didn't include any of the particular facts.
So does it basically? I'm gonna make it short because I kind of feel like I think I know where you're going. Is it basically that okay? Look, you came in and you said y'all were playing, and it was an accident, and you zipped him up as a joke, and you didn't realize what you were doing. But now you're saying, oh no, he was abusive to me, and this was my way of protecting myself. Is that what I'm picking up here?
Yeah, to some extent, yeah. But what they're trying to say here is that because they're not following along the traditional path of what they need to lay out to claim this defense, that they're basically asking for Julie Harper to get up on the stand and give her opinion that Sarah suffered from battered spouse syndrome. And they want the notice to be stricken because there's basically what they're saying is that Julie Harper would be able to get up there and testify through hearsay. And
Okay.
that can't happen, and that's based on the used as a conduit to introduce inadmissible hearsay evidence, such as the defendant offering the defendant's hearsay statements.
I might be opening up a rabbit hole we don't need to go down, but I would understand if they came in and said that Sarah was going through some mental issues. And then to prove that they were going to put that up, they would say, okay, here's Dr. Julie Harper that says she's going through some mental issues, but that's not where they're going.
No, so if it's actually down here in the bottom of 5, and it says Dr. Julie Harper should be precluded from testifying until the defendant testifies to underlying facts that would allow for her expert's testimony.
So you
And
can't bring her up on the stand until Sarah gets up on the stand and talks about how he abused her.
right, she can only talk about hypotheticals. What they're saying here is they can't use Dr. Harper to get Sarah's words in. That's hearsay.
Okay, I get that. But you know what I think we're dealing with, though, after looking up this Julie Harper lady? She seems to be, someone who does a lot of court testimony. She
Mhm.
knows what to say and what not to say, I feel like. Now, that doesn't always mean that they follow the rules. They try to slip by, but I don't know. I just kind of feel like they could still get around this somehow.
Well, so if you keep going, Sarah kind of
Okay, go ahead.
screwed herself a little bit here, because if you see, and these cases that we're seeing throughout this, you see a lot of case law being cited here. We're going to go over that. Like, I have all of that stuff pulled
Okay.
and all pieces highlighted. I just need to sort of put it together so that I can provide a really clear discussion and for you. And I'll send you, the written materials to use however you want. But if you look here, it says, so right here, defendant testifies to underlying facts that would allow for experts' testimony. Okay, so they're saying Julie Harper cannot testify basically on behalf of Sarah. Now we go to 6, and it says the defendant has previously provided statements to law enforcement. Therein, she claims she accidentally left the victim in the suitcase overnight.
She wasn't defending herself.
Battered spouse syndrome testimony is not available if her defense is killing the victim was an accident. And I just read that case that they're citing there. You'll notice that's from 2017. So some of Florida's battered spouse laws go back to the 1990s. But we're seeing here a chain of cases that has come up in the last 10 to 15 years.
So, in layman's term, basically, that sentence right there is the only one we really need to be paying attention to. Battered spouse syndrome and accidental death don't go together.
Right. And so, like I said, I read Wagner, and it's really interesting. And I've got a bunch of these cases sort of lined up, not to get technical, but just to kind of pull out, like, here's how they build to get to a rule, and
You know,
here's how that will fit for Sarah or not. That Marsha Thompson trial, which is
yeah.
that's the one that James Owens references, where she shot her husband 6 times while he was sleeping on the couch, and they did not convict her. But I will tell you, one of the reasons why I think the video would be so interesting for us to do is because of how the contrast between what this woman went through, and the entire trial is not available, but her testimony is.
Hmm.
So there's a couple of crucial pieces, right, that are available in short clips. So I kind of wanted to be able to lay out, here's how we get to battered spouse syndrome, right? These are the elements that have to be met, and they come out of these circumstances. Now let's
Okay.
look at the most recent case, which is Marsha Thompson in Florida, in Palm Beach County in 2023. Let's look at her case because one, James Owens referenced it. I believe he said one of the experts he wanted was from that case. Two, she was not convicted. Three, she shot her husband while he was sleeping. It was
Oh, he
not,
was sleeping.
he was sleeping. But Carrie,
Oh.
the circumstances, the difference between Sarah Boone and Marsha Thompson is gigantic. And what
Okay.
I want your subscribers to see is what the standard looks like, right? From looking at Marsha Thompson's trial and seeing what battered women's syndrome encompasses and what a successful defense of that looks like and what actual um, domestic abuse looks like versus what Sarah is trying to do. Sarah is her
And
own worst enemy. That's the first thing we have to recognize always.
I think too, if you look at some of those body cam videos, she's not somebody that looked that scared in most of them. I don't know. I think we got a couple of body cam videos that they're going to bring up in court, and I feel like those are going to help the prosecution. It says here that it kind of addresses it again. Dr. Julie Harper should be precluded from testifying until the defendant has presented evidence of justifiable use of deadly force.
Right.
She had
So
no he wasn't
she wasn't in
she,
imminent danger.
at the
So
time.
there's self-defense, then there's justifiable homicide, and I forget what the third one is, but I've got, like I said, I've got it all. Just
I
I need
wonder
to
if
put it
I wonder
together.
if James Owens is scared of bringing Sarah up on the stand because of what she'll what'll come out of her mouth.
Well, listen, if he does and she tries to walk back her statements, that's perjury. And nobody's going to believe her because the state has got all of that evidence of her saying it wasn't intentional, it wasn't intentional, it wasn't intentional over and over
Right.
and over again.
Yeah.
And I have
That
been listening. Her voice is stuck in my head now because I have been
welcome to our world.
oh my gosh. Usually
Bec
I only have to go through a recording like once or twice for my work. But your subscribers are so sharp that I have to be able to match their knowledge to some
so
extent.
I
So,
know. You see why I needed you up here?
yeah. I mean, they really have the details of everything that has happened with Sarah down, whereas I had an initial grasp of the case, like I said, back a few years ago, and then just sort of started picking it up again. Um, and so I'm playing catch up with your chat, basically,
Yeah.
or your subscribers. So I've been listening to Sarah on repeat and listening for things where I think because I was intrigued by what James Owens said that he had a problem with the interrogation. So I was going along thinking, okay, what can I see that is a problem here? What is a problem? And that's where I came up with like, okay, did they read her Miranda? But I hadn't gone back and watched the original videos from the very beginning where she is read those. So that was not the issue. Then I was like, I wonder if she was still drunk. Doesn't matter. Apparently, she could still be drunk and still be subject to interrogation. So I'm
So
just trying I was just
I'm
trying
sorry.
to figure out if I could determine what James Owens' problem with that was. And the only thing I can think of now, at least on my however many times through that recording, is she says, I think I need a lawyer.
Well, you know what though, as you were saying all that, it just kind of came to me. I'm like, okay, I hear you saying that he has a problem with the interrogations because she says in there it was an accident. It wasn't intentional. And he can't have intentional and battered spouse syndrome together.
You can't have accidental and battered spouse syndrome together.
So he can't have that interrogation in there messing his case up. If he can get that thrown out, then he can move. He might have more of a chance to do the battered spouse syndrome.
That is
Okay.
not going to happen.
So this is very interesting. Okay, what else do we have on the docket? Are we through with that one?
Yeah, so what I want your subscribers to know is that we're going to come back very soon and take this apart better and give them a better understanding of it. That's what we've been working on.
Some people don't like when we get too in depth into these discussions, and then some people love it. So we'll have it both ways. You know, we are kind of like Burger King. You can have it your way here on the Characters Productions with Carrie and Florida private investigator Sam. Okay, now we've got a notice of provisional witness list. Girl, they're not attaching the damn
I know
list.
I saw they didn't. So
They haven't. And everything, I went through that docket tab. I opened it up every time. They're not attaching the witness list. Where is it? Why can't I get it? Can I ask for it? I guess I can go through the Florida information of request or whatever.
well, I'm to be honest with you, I don't know the answer to this question. And if you remember when I first started talking with you, I had
They
just
wanted to.
come out of a trial and I said I was very unhappy with the state because they were withholding information.
Oh,
We never got an amended witness list going into that trial. Oh no, I take that back. We got ours the Friday before the Monday morning trial. So what this is just telling us is they followed the rule in that they provided the updated and amended or updated witness list, which means, somebody could have come off and they could have put people on, and that they have provided that to opposing counsel. But they don't have to file it into the docket, apparently.
you know what I was just thinking about? Remember when Owens first got up there, his first time, he made a comment about missing some images from the ME's report. I wonder if they've already gotten that information. I think it was there. I don't know why he wouldn't have had it. They said it was supposed to be in Sarah's files.
I believe the state said that they had gone ahead and mailed them to him
Okay.
that same day.
Notice of provision of discovery comes now the state of Florida by and with the undersigned assistant state attorney and gives notice that the below listed exhibits have been disclosed to James Owen and Kevin Beck. Previous depositions, transcripts. I wish they had a list of the people who they had all those. I know who they have on the docket. So everybody they depose is going to be on the docket.
No, the only thing that wouldn't apply is if somebody didn't show up. And that's
Okay.
those depositions might not mean that the person is going to testify. Florida is one of the few states in the country that allows depositions in criminal cases. It's very common in civil cases, but not in criminal.
I
And it's sort of like you get to test out the witness before the witness takes the stand. So if we want to call somebody, if Sarah wants to call somebody, they have to tell the state, hey, Sarah wants to call Dr. Julie Harper. And the state has to have a chance to depose Dr. Julie Harper to find out what she's going to say. And you can
so
do that all the way through the police report.
I hate to say this off the top of my head because I'm probably going to forget somebody, but okay, I'm going to go back and tell you who I think. I know there's a
Okay.
list of who's been deposed, and I might be cross referencing some stuff here because I don't have all of my stuff in front of me, but I just want to throw this out there, you guys. Okay, there's two witnesses that I'm unsure of. There's a Devin Jamro, I think I'm saying that right, and a Janice Robinson. They're probably witnesses at a bar, the local bar there that they were at, supposedly. They
Mhm.
could be witnesses around the neighborhood, or they might be affiliated with law enforcement in some way. I'm not quite sure. But
Could
those
they
are the
be a
two that
neighbor?
huh?
Could they be neighbors?
They could be. I just couldn't. Everybody else that they had pulled up to look at and talk to, I was able to figure out who they were. Like for
Mm.
instance, there was one lady that came in, and I could tell just by the way that the deposition request was written, she was from the crime scene investigation portion. She was from law enforcement. So you've got your two detectives that are going to be questioned. You've got the medical examiner. You've got Diane Johnson at this auto body shop, which I don't know if they're going to bring her in or not, but they did give her a deposition. And then we've got a couple of neighbors. We've got the two of them we know gave statements, testimony. And oh, three of them actually, because then if you add the apartment manager. But
Mhm.
then see, there was other people. There was his family. When Padilla was on the stand, they had done a subpoena for Moses, his one of his brothers.
Mhm.
Now we know that was for a trial that never happened, or the dates the trial didn't happen back at that point. So they'll have to resubpoena him if they're going to go that route still. But from what I could see, he was like one of the only ones. Him and Brian, her husband, her ex-husband, were the only ones that I saw solid subpoenas for.
Okay, that may
So,
be true. And so those would be state witnesses. So whoever the attorney was at the time of taking the deposition, that's who would be asking the questions, and the state has the right to obviously to be there too. And the whole thing is recorded.
and then we feel like Sarah's going to try to bring in, well, I don't know. Now that she's got an attorney that's looking at this from the outside in, it might be that they realize that Melissa may hurt her more than help her. I don't know. And I think there's a lot of us kind of feel differently about that. People in the chat have disagreed with me. Some have agreed, some have disagreed about the way I feel about that. I just feel like Melissa's not going to be that great of a witness for her.
Oh, it'd be terrible for Sarah. I don't think she'd be a good witness for Sarah at all, based on what I've been listening to, unless I'm missing something.
And I
She
could just hear Sarah. She's over there going, "Did you talk to Vinny? Did you talk to Vinny? Oh yeah, we talked to Vinny, girl. Vinny next door. We talked to him."
she said, "I can't get drunk." And then it's like cut to the apartment manager. They were drunk by 9 o'clock in the morning. And then
I don't want to
also
get
we have
drunk.
footage of her from the other calls where she is very clearly drunk. So stating in her interview that not only does she get straight A's, excels at everything, but she also can't get drunk, doesn't want to get drunk because she wants to keep her, what's her Latin phrase that she likes so much?
Minicopus or something.
Yeah,
Minicopus.
yeah,
I don't know.
exactly.
She, it's just I got to do another one of those videos where I edit the words and her
Oh,
actions
yeah,
in there
there
again.
was a clip of something I was watching today that I was like, "Oh my god, Carrie should totally put this in there," and now I don't remember what it was.
I'll have to play around with that. I've been so busy trying to keep up with what's going on with the docket. I haven't had a whole lot of time getting creative with that stuff, but that
But
would
you
be.
did such a good job with it, and I heard something in the when I was listening today, and I was like, "Oh, that would be awesome." So I'll have to try and figure out what that was, 'cause
You know, I
that's a great intro that you've done.
Thank you. I did something like that when I was working on the Daryl Brooks trial, and I think that I did a whole video on his contradictions, and I felt like, you know what? That might be not a bad idea to do with Sarah. Sarah's
Exactly,
contradictions.
exactly. So part of my job is to take any recorded statements, under oath statements, sworn statements, I guess, depositions, whether I have recordings or transcripts, and compare them to previous statements, because that's what you're looking for impeachment purposes. You want to find those contradictions. So
Yeah.
Sarah is an excellent candidate for that. And, you know, this is going to be a really interesting trial. It's either going to be a circus off the rails or it's going to be nothing. And I can't figure out which, except I think that new defense attorney is not going to let it be nothing. So it should be entertaining.
Yeah. I can't help it. I forget that we're trying to get justice for somebody sometimes because I don't know, maybe I do have the passion I have the passion to get justice. And every time I see something about Jorge, I get like I like him. There's something about him I like. And
Yeah,
I
he
can't
seems, yeah, I agree. It's
and
really hard.
yeah, and so I hope people understand that we'll talk about it sometimes about it being an entertaining, trial or is this going to be a shit show or is this going to be something that we're like, yeah, we're going to be enjoying watching it, but I think a lot of us have the passion for George as well. So, we'll see. I don't know.
Yeah, I agree, and I try to make sure that I remember that there are victims.
All right, Sam. Well, thank you so much for being here with me today. I appreciate you, and we'll get to work on that other stuff, and then we'll be back soon for more for everyone.
Thanks so much for having me. It's always so much fun.
Y'all be good and be kind to one another.
Bye.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.